It is time for today's Talkback segment. Each day we post a question on CourtTV's social media pages. We gather your comments and questions and then respond on the show. Today's question: is Durst too ill to take the stand to testify? Still with me is Deputy Public Defender for Los Angeles County, Philip Dube. And our first comment comes from Jerry Cooper. She says the physician who testified made it sound like Durst should be in a hospice. Why is he sitting there in court when he supposedly needs treatment to keep him alive? Does Durst have a doctor that has actually done tests on him? Why would taking the stand kill him when he's been fine sitting there and taking part? And we've kind of addressed this, Philip. At the end of the day, you know, he seems very engaged. He seems competent. He seems able to assist in his defense. Clearly, he's even yelled at his own attorneys. I mean, it's pretty, I don't think it's going to fly. No way.
No way. He gives them the fist bump. And not only that, let's assume he does take the stand and he gets a little fatigued and winded. They can always accommodate him. That's what the law allows. You take a break, maybe come back in an hour, or if need be, you adjourn for the day and come back the next day until you're done. But I'm telling you, if you do it in piecemeal like that, John Lewin's going to have him on the stand for the next millennium.
You know, speaking of John Lewin, you're out there in Los Angeles County. I'm sure you've come across John Lewin. What do you think of his style? You know, there's times where I feel he's a little bit abrasive, maybe too much so. And I wonder how that might look in front of the jury. What do you think about John Lewin?
Well, first of all, he's very quick on his feet, and he's extremely scholarly and very, very knowledgeable of the law. I always admire any lawyer who knows what they're talking about in fact and law. I can get past, you know, personality issues and style, etc. Every lawyer has a different style. But in the end, if you know the facts of your case and you know the law and you present well, it's effective. And I think that the jury has embraced him.
I cannot disagree with you. We can quibble about, you know, all of his sort of histrionics, but there is no question that he knows this case. All right, let's go to our next comment. It's from Kathleen Martino-Leppert. She says he should be left alone. He's dying. Look at him. What's the point? It's barbaric treatment. Let him live his last days in peace. And that's something I wanted to discuss with you. You touched on it a little earlier, that there may be a couple of jurors who may feel a certain way about him. And I'm going to call it jury nullification, for lack of a better word. Is it possible that that could take effect here, that some of them may feel exactly like she feels?
Of course. And quite frankly, if it's not the sympathy factor, you know, you may laugh, but there's this ongoing sort of debate in the defense bar where we think some victims need killing. You know, it could very well be that some people actually despise Susan Berman and what she stood for and how she tried to shake Durst down for money, how she treated people and how she grew up in the mob world. She might not be a sympathetic victim.
I agree with you. I think that's one of the issues in this case, is that Susan Berman doesn't come off as the nicest person or the most honest person. So she told all these people a lot of different things, but people have said that she, you know, could play with the truth a little bit. So that may play a role as well. Let's go to our next comment, and it's from Savannah. Let him speak so we can judge from his speech coordination. Insane persons can't string two words together coherently. I don't think the issue here, Philip, is about insanity, right? That's not what this is about.
No, but the general rule is, and I'm sure you've heard this expression or the old adage is, the road to state prison is paved with many a man who took the stand. Okay. And one of the dangers of putting a client on the stand, especially in his condition, is that if he can't formulate a sentence or if he can't get the words out, it might look like he's lying, you know, and the jury might think that, well, all his frailties and maladies and infirmities aren't enough to cover this up. So it's risky.
Yeah, it is risky, but it might be their only chance. All right, Philip, I want to thank you so much for being with me. Had a great time. Appreciate your insights and all your information. Thank you again. I'm Michael Ayala. It's been a pleasure being with you. Coming up next in Closing Arguments, Vinnie Politan takes a look ahead to the North Dakota murder trial that